Good morning, folks. This is the Colorado Oil and Gas Conservation Commission. It is Wednesday, January 27th, 2021. It is 9 a.m. and we are going to get our regularly scheduled meeting going here. We will start with roll call. Hearings Manager Amaro.
Yes, Mr. Chair. Commissioner Gibbs?
Here.
Commissioner Gonzalez?
Here.
Commissioner McGowan?
Here.
Commissioner Mesner?
Here.
Commissioner Nanjapa?
Here.
Commissioner Hackett?
Here.
Commissioner Robbins?
Here.
Mr. Chair, you have 7 out of 7 commissioners present today.
Excellent. Welcome. Good to see everybody. We've got 36 participants with us. Our agenda this morning starts with public comment, and we have, I believe, 6 people signed up for public comment. Hearings Manager Amaro, if we could go down the list and identify the speakers. I believe it starts with Lucy Molina.
Yes.
And what we'll do with public comment is we'll bring each speaker to the fore, and each speaker will have 3 minutes for public comment. We may have questions or not, but we look forward to entertaining public comment here at the Colorado Oil and Gas Conservation Commission.
Mr. Chair, Ms. Molina is not in yet, but Ms. Noble is in. We can start with her.
Okay, great. Susan Noble will be brought to the panel.
Good morning, commissioners.
Good morning. We can hear you just fine.
Thank you very much. I appreciate the opportunity to speak with you again. I was a speaker during public comment on January 6th about the extraction pelican and blue jay applications. Today, though, I am here to talk about the Great Western Oil and Gas site, Edmondson. Edmondson is 24 wells. It's sited on the north side of E470. I want to draw your attention to it because the Edmondson well bores would frack from unincorporated Adams County under 470, bypass the Adams County Government Center, and angle off under homes in Commerce City. This is the Outlook subdivision of Commerce City with some 700 families residing there 24/7. The county gave its blessing to the Edmondson site in 2018 under its AUSR program with the COGCC. Since that time, however, Adamson County has dissolved its MOUs. It implemented its own oil and gas regulations, and of course, the regulations and rules that the COGCC has enacted have come to pass. To the north of Commerce City's north boundary are 4 megapads in Adams County in nearly a straight line, with northern winds blowing emissions over the communities of not only Outlook, but also Buffalo Run, Reunion, Buffalo Mesa, Buckley Ranch, Frontera Village, South Lawn, East Point, and Buffalo Highlands. All are located in Ward 4, which is the ward I represent as a council person, but I am not here as a representative of the city council or the city today, but as a resident. When there are northern winds, we pick up air from as far away as Weld County. So we have Prairie, also Great Western on 136, which will have 20 wells. This site is before you in February. 550 feet away is Brighton Lake site, that's 8 wells. Extractions PC North on 128th is 20 wells, and Edmondson, which is also Great Western, around what would be 124th or so, is 24 wells. That's 72 wells total within a mile of each other, with Edmondson only 3/4 of a mile from the Outlook neighborhood. So my purpose today is to simply let you know that these are all coming forward. This is part of a very, very large incursion on Commerce City. Extraction has 7 sites alone. And of course, we have the Great Western site in Adams County that would frack into Commerce City. So I just want to draw your attention to these today. And I thank you for the opportunity to speak.
Thank you, Ms. Noble. I guess I would, my response would be that we would encourage you to participate in these permit applications as they work their way through the COGCC process. That's what our new rules allow. And so while we appreciate you bringing to our attention these matters today, we would encourage you to be involved on your behalf or on Commerce City's behalf as those applications come before us.
Thank you, Chair Robbins. I'll be happy to do that. To be honest, I wasn't clear that you were going to be having public comment regularly at your commission meetings, so I thought I would take this opportunity when I saw that you were blocking time. But I'm more than happy to come back on the days that these applications actually are before you.
Yeah, of course. And, we're, building the ship as we sail it. And we're meeting once a week, which is much more often than the previous volunteer commission. Presently, we are taking public comment twice a month, once at a meeting in the morning and then once during one of our evening meetings. We frankly have not had a lot of people sign up for public comment, so we think that this is about an appropriate amount of public comment. So again, we appreciate your being involved today, but would encourage you to be involved on site-specific applications that you're concerned about.
Thank you. I'll do that. Appreciate your time.
Great. Hearings Manager Amaro will either go back to Ms. Molina if she showed up or move to Christy Douglas, who also.
Ms. Molina is in. I will access her now.
Hola, buenos días. Can you hear me?
We can hear you, Ms. Molina.
Thank you so much again for this space and this time. God bless you. Good morning. Buenos días. Thank you all for your public service and for the work that you do. This morning, my family's right now dealing with the corona. My mother just went through the coronavirus, and also my daughter's now in quarantine. She's in isolation right now. So I thank Susan Noble for advocating for our community. That really moved my heart just to, you guys all know how I am already. And, inclusion matters. Today, I want to remind you of your mission, amigos. So it says your mission, advancing Colorado's health and protecting the places where we live, learn, and work. The vision is a healthy and sustainable Colorado where current and future generations thrive. I saw that there was over $500 million of federal funding and fees and grants. I just don't see where that, even listening to Ms. Noble here, and as you know, I live here next to the oil refinery Suncor. I don't see myself included in this vision or in this mission. I do appreciate the work. I've been studying your strategic plan. I still am like, okay, equity, I hear equity, more environmental justice. I just want to let you know that we are not asking for a favor. I'm advocating for my community and for the future of Colorado. I ask that you follow through with what is due to our community. Again, I thank you for your service. Right now, I always try to bring it down to the human, what we're really going through, okay? Because I don't identify myself with a lot of this commission. Maybe one person here on this commission, I would say. But, I'm bringing it down from the technical terms and all the stuff that, the VOCs and all this stuff to what we're really dealing with. In the coronavirus, my mom is a diabetic. My daughter has issues. We all do. This is the reality, okay, of what happens to communities like mine when we don't take action. Again, I ask you to follow through with what is due. Thank you so much for your service, and I will continue to be here. Hopefully, next time I'll bring my more people with me. Gracias, and God bless you so much for the work that you do.
Thank you, Ms. Molina, for those words and for participating with us this morning. We appreciate it. We would now turn to Christy Douglas, followed by Steve Douglas.
Mr. Chair, Christy and Steve are not in the room yet. We can go to Sarah Cutler or Vicki Cutler.
Okay.
We can do Vicki first.
Good morning.
Good morning.
Vicki Cutler. I'm going to be reading my 3-minute spiel that I think I have. I have a degree in medical science. I believe in a climate crisis, and I believe we all need to take action to protect our Mother Earth. I am a mother and grandmother. Everyone should know that mothers are very protective of our families, protective of our children and grandchildren, protective of our homes. So this is personal. Since moving here in August of 2017, we have had to attend numerous oil and gas meetings to try to protect our human rights. We citizens, the real people and lives you are impacting and making rules and decisions about, would like to protect our home investments, clean air, and drinkable water. Most of all, we would like to protect our children, grandchildren, and future generations. In 2019, we were provided a second opportunity to protest to keep 8 drilling and spacing units from destroying our home and neighborhood community. We came prepared for a pre-hearing conference with expert witnesses and 27 other protestants in attendance to discuss concerns about the cumulative effects of 8 drilling and spacing units in a high density area. Instead, the pre-hearing conference was focused on Extraction's desire to bifurcate and split our community into separate spacing units so they could weaken our ability to protect our homes. We were told by the hearing officer that we needed to obtain legal counsel or our protests would be dismissed. Homeowners should not have to be required to obtain specialized legal counsel to protect their health, safety, and well-being. Those who benefit most from mineral wealth tend to live far away from fracking sites, while the environmental and health burdens remain local and fall hardest upon those who do not have a voice in decision-making processes. This environmental and social injustice must stop. People must come before profits. More than 230 known wells are proposed. The cumulative impact of the concentration and intensity of industrial activity surrounding and infiltrating neighborhoods where nearly 60,000 Commerce City residents live must be recognized and addressed. Commerce City and Adams County already have serious environmental hazards with Rocky Mountain Arsenal and Suncor. I encourage you to view CNN Planet Earth, Poisoned Earth, Rocky Mountain Arsenal on YouTube. Before you decide to allow more oil and gas permits in densely populated neighborhoods, consider the serious negative impact on human life and wildlife for all of Colorado and our future generations. Thank you.
Thank you, Ms. Cutler, for participating with us this morning and providing your perspective to us. I would just note that our new rules that became effective on January 15th of this year, just a couple of weeks ago, do indeed work on cumulative impacts and allow us to look at things from a more holistic perspective. So again, we appreciate you bringing the perspective to us this morning. I believe next we had Sarah Cutler, perhaps someone you're related to.
Good morning.
Good morning.
So I wrote a speech, obviously not hearing what your responses were today, and Essentially, I'm a litigation paralegal, and I have been for over 7 years, and I helped our community with writing and formatting our protests, because a lot of our neighbors were getting their protests denied for not having them in a legal format. I am used to working at jury trials in federal court defending large companies from discrimination claims. And so basically, I'm a trial technology geek who displays exhibits for juries. I need to be quick enough to find exhibits, display them, highlight them, and blow up sentences to make them have the largest impact as soon as they leave attorney lips. And so it's my job to create the biggest impact when showing evidence. And I can't do that in 3 minutes for you guys, but I hope that all of you know what the cumulative impact of all these oil wells would do to my community, to my mother who just spoke, and to everyone around us with these proposed drills. Helplessness is what a lot of my neighbors feel. And I feel like that's part of the reason why they're not speaking up. It does make me sick, writing speeches like this and preparing for meetings like this. Personally, I'm on the clock right now, and I could get in trouble for not working right now and losing billable hours. But I hope the risk is worth it. So I don't really know who all you are, if you're an extended branch of defending oil and gas development, or if you truly have residents side. So, but basically my neighborhood does have a history of getting dumped on. We're right next to the Rocky Mountain Arsenal. We have some of the worst drinking water in the States. And the cumulative impact of proposed oil and gas activities are unnecessarily close to our homes, and this is unjust and discriminatory. My community has been basically dumped on because of lack of economic and political clout and lack of having a voice to say no. And this is a prime example of environmental injustice. When making decisions regarding the proximity of oil and gas activities to homes, seeing how the market responds is a form of evil. We all know that these affordable houses are going to be bought by people who can't afford to live anywhere else. And income now has become the key factor that influences one's exposure to the ruins and health impacts caused by oil and gas activity. So this is really a prime example of a good versus evil story. The good guys are the honest, hardworking folk who want to live healthy lives, and the evil guys just care about their money no matter what the costs are to others. And I just would like to know whose side are you on. Hopefully you are listening to us today. Thank you.
Thank you, Ms. Cutler, for participating with us. A couple of points. I note that you feel that 3 minutes is not a lot of time, and you had a lot more to provide to us. You know, feel free to type up whatever it is that you would like us to know about and submit that to us electronically. That's always available. You also can reach out to us individually, and I'm sure that we'd be happy to sit down and talk with you about who we are and what we're doing on behalf of the state with regard to our new mission of regulating in a manner that's protective. So again, thank you for participating with us today, and we look forward to further participation with you.
Mr. Chair,
Yes.
just to add, to let folks know, you don't have to take time out of work to testify in front of the commission. Our third meeting of the month, the third Wednesday in the evening, is in the evening, and we're taking public testimony on those nights, I do believe. So folks can talk to us in the evening too, and don't feel like they need to take time off from work.
That's a very good point, Commissioner McGowan. I appreciate you reiterating that for folks so that they're aware of that. Hearings Manager Amaro, did any of the other folks that signed up for public comment, are they in the house?
They could be. We have 2 numbers that don't have a name, and if that is Christy or Steve, if you could raise your hand, and I can let you in.
I'm not seeing any
No.
hands being raised. Perhaps that's not them, and maybe they're not in the house with us at this point. What we can do is we can move forward with our agenda and perhaps give them an opportunity, if they show up before we adjourn today, we could take their public comment at that point. With that, the next matter was a report from Director Murphy. I see Director Murphy's with us.
I might be with you in video only, as I can't find unmute and all sorts of other things. I'm caught a little flat-footed. I have a very, very short report today, Commissioners, in that we are really continuing to focus almost exclusively staff's efforts on implementing the new rules. Again, on the permitting side and on the form side, we launched 14 new forms between January 15th and January 18th, 2021 to implement these rules. We have had a few permits filed, and that's pretty exciting for us as we're learning how to do work anew under this new regime. And on the field side and on the environmental side, continuing to work on compliance with those new regulatory requirements. We are planning to continue either bi-weekly or weekly meetings with industry on the implementation side, kind of depending. We're trying to strike the right cadence to make sure we're providing the right amount of information at the right time. And so those will continue. We are continuing to issue guidance and move through that. A couple of staffing or operational updates. I think I neglected to mention that Bob Cutler, our UIC lead, retired at the end of December, which was a huge loss to our organization. And Mark Morton, formerly our LGL for an extended period of time, and who had recently transitioned to the Orphan Well program, is also retiring at the end of January. He established a number of really excellent relationships with our local government partners, and so I wanted to make sure I acknowledged both his retirement and Bob's retirement and their service to the state. And again, staff is just entirely focused on implementing these new rules and making sure that we're moving things forward swiftly and effectively, and in communication with other folks. So with that, Chair, I don't really have anything else. We're happy to take questions, and I think I see some chats that we might have a public commenter queued up or ready to go. So I will remute myself and turn it back over to you.
Great, thanks, Director Murphy. We send our best wishes to both Bob Cutler as well as Mark Morton. I know that they were very important to mission of the commission and did great work there. And so we look forward to their success in whatever they're doing next. And the commission express its thanks to staff for the tremendous effort that it undertook to get the new rules up and running. We're very proud to have the new protocol in place, and it's exciting to see that we have operators filing for permits under the new regime, and we'll look forward to those coming before us as a professional commission for reviews. So with that, Hearings Manager Amaro, were you able to find Ms. Douglas? It looks like someone said she's on the phone.
She is on the phone. I've asked her to raise her hand. We have 2 phone numbers, so I'm not sure which one she is. So Christy, if you can raise your hand or let me know which one is your phone number, I'd be happy to let you in.
Yeah, I see a phone number ending in 19 and a phone number ending in 94.
Yes. Okay, 19 it is. Just
19.
one moment.
Ms. Douglas, if you want to unmute yourself.
Hello.
Hello, we can hear you now.
Oh, great. Thank you so much. I am so sorry to not have a hand to raise today, but these are my circumstances, so I am so glad to be able to be a part of this. My name is Christy Douglas. I am a concerned citizen of Adams County and Commerce City. I have been away for the last 6 months taking care of my mother, who was in hospice. Happily, she has made her way out of hospice, and my job to help her recover is finished, and I'm happy to say that I'm back in action. Wow, I feel so rusty with this because I've been away for such a long time. I really wanted to echo the concerns of all the other people who spoke this morning. As much as I've been away, I feel like nothing's really changed. I really appreciate the fact that you have all done a really good job in making the rules better. I applaud you for setting the 2,000-foot setback. But what I see is that business is taking place as usual. And I see a site going up like Ivy, the Ivy site, which I've fought to keep out of that neighborhood for the last 5 years. I see it going up and it breaks my heart. I can't believe that this industry is allowed to operate anywhere it pleases with no consideration on the impacts that they have to the areas, the people in the areas that they decide that they need to access to do their work. And it's not even work that's necessary. It's work that makes money for them. Otherwise, they wouldn't be doing it. This is only about money. I really appreciate that you are taking public comment as much as you are. I like the fact that you're doing an evening session, but as Sarah Cutler mentioned, so many people are just so scared to get involved. First of all, they feel like no matter what they say, it's not going to change anything. So why waste their time? They're scared of the impacts that it's going to have on their families, on their health, their safety, their property values. But they feel like they're just being steamrollered over, and they are. Essentially, they are. That's what I feel like. That's what my husband feels like. My husband, unfortunately, had to go back to work, so he won't be able to speak today. But please, don't continue just to give us lip service. We can't do that anymore. Rules do nothing to curb drilling. The only way to minimize impacts is to minimize drilling. And I don't see that happening. You're passing out permits, like I said in the past, like Halloween candy, and you continue to do it. Even with the new legislation that's been put in place with 181 and I believe it's 1261. What is going on here? That's what I'd like to know. So please know that there's lots of people out here like me who don't enjoy doing this, but feel compelled to protect ourselves by speaking out. And by God, I am going to rally the troops and give them the courage to come and let you know how we feel. This is not right. Thank you for your time.
Thank you, Ms. Douglas, for getting back in the game and being with us. I'm happy to hear that your mom is doing better, and would note that if you're feeling rusty, that you can go to our website, and on the very first page of the website, there are links to all the work that is being done. There are guidance documents for citizens so that they can see how to be involved in what we're doing. I disagree somewhat that we're not doing things. We're doing quite a bit. We implemented SB 19181 with numerous new rules that do allow for the public to be engaged. We would encourage you to be engaged, and I, for one, would be happy to sit down and talk with you further so that you do not feel unengaged with what we're doing. I would not be able to speak about specific locations because we're now involved in the permitting, but happy to talk generally with you and to reach out in that regard. So again, thank you for coming to us this morning and taking time out of your day. As Commissioner McGowan spoke, we also are doing evening engagement on the third Wednesday of each month. So there's that opportunity, and you can also get involved by providing us with written perspective. So thank you again. And you mentioned that your husband, Steve Douglas, is not able to speak. We did give you some additional time so that you could use some of his time as well.
I appreciate that. Thank you very much.
Mm-hmm. Hearings Manager Amaro, are there others that were signed up that are with us, or are we through with everyone who signed up?
We are finished, Mr. Chair, everyone that has showed up that signed up.
Okay. And again, just for everyone, members of the public, we do encourage you to sign up ahead of time for our meetings. We're doing these, continuing to do the meetings remotely via Zoom due to COVID and DNR protective measures from working from home. And having you sign up ahead of time gives us the ability to identify people, bring them to the panel, and then move through the process. It makes it much more, it's much easier for us to do that. And if you want to sign up ahead of time, and then if you decide you don't want to speak, that's fine. We'll just, skip over you, but you can perfect your ability to potentially speak that way. I also, as I mentioned to Ms. Douglas, encourage members of the public to go to our website. It is a highly informational docket, and you can see all of the guidelines that staff has put together to help implement the new rules that are in place now. With that, we will continue in our agenda, and I believe at this point we are going to initiate some of the informational dockets that the commissioners have desired to have. We're looking to get educated with regard to oil and gas and the work that we're doing, and we're going to start that with a presentation by Ms. Jane Stanzik, the Permit and Technical Services Manager, and John Peskin, one of our hearings officers, and they're going to present on pooling applications and orders.
I'm going to get Ms. Stanzik's presentation up, and just it'll take me one moment. Presentation is ready to go.
Great, we can see the presentation. Ms. Stanzik, I believe the floor is yours.
Thank you. Good morning, commissioners. But first I need some help from Ms. Amaro. And are you going to advance my slides for me?
I will do so.
Thank you. Thank
You're
you
welcome.
very much. Appreciate it.
You're welcome.
Thanks. Good morning, commissioners. My name is Jane Stanzik, and I am the permitting manager here at the commission. This morning, I will use a few slides to illustrate some aspects of spacing and pooling. But first, I need to introduce a little terminology and some concepts. Next slide, please. Spacing and pooling apply to the ownership and production of hydrocarbons, oil and gas, in the subsurface. Two terms we use to talk about subsurface minerals are lease and lease lines, even though the mineral rights are actually have another basis. And please note that when I say oil or minerals in this presentation, I'm actually always referring to oil and or gas. In the statute and in the rules, a mineral owner is the person or entity who has the right to drill for and to produce oil and gas. Next slide, please. When a well drains oil from a subsurface reservoir, the oil actually moves through the rock. The distance it can move through the rock to a completed well is called the drainage radius, typically measured in feet. The drainage radius depends upon the properties of the rock and the reservoir. In this slide, the red star represents a vertical well. The black arrows represent the movement of oil through the rock to the completed well, and the yellow circle illustrates the area to be drained based on that drainage radius. Next slide, please. In this slide, the colored rectangles represent leases and lease lines. The red star well is draining beyond the lease that it is drilled on. It's draining oil from adjacent minerals. Next slide, please. If the owners of those adjacent minerals quickly drill their own wells, their minerals will not be drained by the red star well. Next slide, please. Which is exactly what happened before states had oil and gas commissions. Next slide, please. And that is why the protection of correlative rights is one aspect of this agency's regulation of oil and gas development. Next slide. Correlative rights means that a mineral owner must receive their fair share of the production from a well that is developing or producing their oil and gas. And I would note here that in practice, receiving your fair share is actually your fair share of the proceeds from the sale of that oil and gas from a well. Next slide, please. So the most straightforward way to protect correlative rights is to require that a well only drain one lease. And that's what Rule 401 does. It assumes that the drainage radius for a deep well is 600 feet or less, and that the drainage radius for a shallow well is 200 feet or less, and it requires that the well completion in the subsurface has that minimum setback from the lease line. But this method has some limitations, including preventing the development of smaller leases and not considering the actual drainage radius of the reservoir being developed that would facilitate the most efficient development of the minerals. Next slide, please. Fortunately, the statute gives the Commission a mechanism to protect correlative rights that does not have such limitations. That mechanism is the authority to create drilling and spacing units and, when necessary, to pool the interests within them. Spacing considers the specific properties of the reservoir to ensure that the order establishes a unit of the appropriate size and protective well completion setbacks from the unit boundary and the appropriate number of wells. Next slide, please. So in this slide, we're back to the red star vertical well, and the red rectangle illustrates a drilling and spacing unit established for that one well. Next slide, please. As you know, horizontal wells are the dominant type of well drilled in the DJ Basin and is also more and more commonly drilled in the San Juan Basin. Next slide, please. Without the use of drilling and spacing units to combine multiple leases, the development of reservoirs using horizontal wells would be limited to only larger leases, as a horizontal well typically drains multiple leases. Next slide, please. Now we're back to the drilling and spacing unit for the Red Star well. If all 8 mineral owners within the unit are happy with the development of their minerals, they will voluntarily pool their interests by entering into a private agreement that addresses the division of drilling and operation costs and the division of the proceeds. However, there may be mineral owners who are not happy with the development of their minerals and decline to pay their share of the costs. These owners are referred to as non-consenting, and in this illustration, they're the white and blue rectangles with red X's. Next slide, please. In such a situation, the consenting owner within the unit can apply to the commission for a pooling order. This is referred to as involuntary or forced pooling. The statute and Rule 506 set certain conditions to be met before such an application can be made to the commission. There must be a drilling and spacing unit. The non-consenting owners must have been provided offers to lease or to participate in the well. And the applicant for the pooling must own or have the consent of 45% of the mineral interests within the unit. Next slide, please. A pooling application may request cost recovery because the consenting owners have carried the non-consenting owners by paying their share of the well costs. The consenting owners recover their costs out of the non-consenting owners' proceeds from the well's production. The non-consenting owners do not pay anything out of pocket in the cost recovery phase. The recovered costs include 100% of tangibles and operating costs and 200% of intangible development costs. During the cost recovery phase, the non-consenting owners do receive royalty payments. These are set by statute as 13% for a gas well and 16% for an oil well. After the cost recovery phase, the non-consenting owners become participating owners who own their full proportionate share of the well. That's all I had as my presentation. Are there any questions for me before Hearing Officer Peskin describes the parts of a pooling order?
Sorry, needed to unmute. Commissioner McGowan?
Thank you, Mr. Chair. Thank you, Ms. Stanzik. Could you, back on an earlier slide, 401C and 401B, where there's a 200-foot setback versus a 600-foot setback, is that dependent upon the type of drilling that is occurring?
It's dependent upon the depth of the well. Because in general, a deeper reservoir, deeper rock formations have a higher pressure, reservoir pressure, and that means that they drain a larger area, whereas a shallower well has a lower reservoir pressure and drains a smaller area. So does that make sense? And that's right in the rule itself.
Okay. It didn't make sense to me because the drilling depth looked the same to me on your slide for each of, for 401B, A and B, and so it was confusing.
Did it have a typo?
No, maybe I misunderstood when I saw it. So that makes sense to me. Thanks.
Ms. Stanzik, just to clarify, the 100% and the 200%, those are all statutory, right? And
Yeah.
the commission is not involved in changing that or, okay.
Yeah,
And then,
that's it. That's spelled out in the statute.
Who determines whether the well is an oil well or a gas well relative to the 13 or 15%, I can't remember what the numbers were. And because, I know that at times there's both oil and gas that comes from a well. And so is that something that the commission is involved in, or is that more of a private issue between the parties?
At this point, I'm not aware that it has come before the commission. I think it's private between the parties. The state of Colorado, the Department of Revenue sets the determination of and we use the determination of the distinction of an oil well or a gas well is based on the gas to oil ratio that well produces, and that's called, we call that the GOR for gas to oil ratio. And the cutoff in Colorado is 15,000. So above 15,000, it's determined to be a gas well, and below 15,000 is an oil well.
Ms. Stanzik? So that 15,000, that's based on a unit of gas, or 15,000 units of gas to 1 unit of oil. Is that a cubic foot? Is that a 1,000 cubic feet? So is it 15,000 MCF to a barrel? Is that kind of how that ratio works?
Yeah.
Okay.
Other questions for Ms. Stanzik?
I've got a question, Mr. Chair, to kind of follow up on your question that I think could have some more clarity. Is when a permit is filed, is the type of well determined at that time by the operator, meaning based on their anticipation of how that production works? And then my follow-up question, or my second question, part of that is that, does that ever change over time?
Yes. So on a Form 2 application for permit to drill, the operator does indicate if they're anticipating the well to be a gas well or an oil well. After they've drilled and completed the well, they again designate on their completion reports to us whether it's a gas well or an oil well based on the initial test, the GOR of the initial test. And it's in many of the reservoirs in Colorado, as the reservoir is produced, as the well production declines, that GOR does change over time, and typically the amount of oil decreases and the amount of gas increases. We do not reclassify the wells. In fact, we don't track in our database the number of gas wells or the number of oil wells, because it does change over time. We, of course, based on the production reporting, we can look at any given time at the monthly report for a well and say, oh, this is above the 15,000 or below, but it doesn't impact anything we do.
Commissioner Gonzalez, did you have follow-up? Otherwise, we'll turn to Commissioner Messner.
Nope, just thank you, Ms. Stanzik.
Thank you, Mr. Chair. And just to follow up on that, so the determination of whether it's an oil well or a gas well, understanding that in both the oil well, the classified oil well and the classified gas well, there is both oil and gas, is the royalty is still paid on both products. It's just determining what the percentage of royalty is, correct?
That's my understanding of that statute.
Okay, thanks.
But I'm not an attorney.
But you play one.
I hope not.
Others with questions for Ms. Stanzik? Otherwise, we'll turn to Mr. Peskin.
I've got one more question I think we could add to this conversation, Mr. Chair. Ms. Stanzik, could you give us a little more insight into the difference between a non-consenting working interest owner and a non-consenting unleased owner? Because those are two of the typical interests that we see in a pooling application.
Right. So an unleased, non-consenting or non-participating is just a mineral owner who has declined to lease their minerals to an operator who's looking to develop. And that's just simply that. They didn't like the offer, or they just have not leased their minerals. In the case of a non-consenting owner who might be, the holder of the lease, they just sometimes they don't consent because they don't, like the costs involved, but they could be and often are another operator that has that holds the lease, and for whatever reason declined to participate.
Thank you, Ms. Danzig.
Not seeing any additional hands raised. Thank you, Ms. Stanzik, for your presentation.
Thank
Now we'll
you.
hear from Mr. Peskin.
Good morning, commissioners. Can you hear me?
Yes.
Okay, thank you. So I want to thank everyone for the opportunity to present this morning regarding pooling orders. I also want to thank the commission for giving me a reason to put on a collared shirt, so I appreciate that. I am going to drive myself, which means I'm probably going to screw this up somehow, so please bear with me. Okay, can everyone see the slideshow?
We can, thank you.
Okay, terrific. All right, as I stated, my name is John Peskin. I am a hearing officer here at the COGCC. I'm also a licensed attorney in the state of Colorado. In fact, both hearing officers currently at the COGCC are licensed attorneys, myself and Elias Thomas. And speaking of Elias, I used one of his pooling orders that the commission recently approved. So if there are any mistakes, I just want it noted that they're entirely his fault. So what is pooling? There are multiple definitions of pooling, and we'll begin at the beginning. The first one is the statutory definition. And basically that is, it comes from CRS 3460 101, which is our definition period, our definition section of the statute, which states that the term pool means an underground reservoir containing a common accumulation of oil or gas, or both. Each zone of a general structure, which zone is completely separated from any other zone in the structure, is covered by the word pool as used in this article. And that's important because in 3460 116 6A, more commonly known as our pooling statute, comes from our Oil and Gas Act. Pooling, not the statutory definition addresses the term pool, but pooling is actually defined as when two or more separately owned tracts are embraced within a drilling unit, or when there are separately owned interests in all or in part of the drilling unit. Then persons owning the interests may pool their interests for the development and operation of the drilling unit. That word "may" is important because it's a distinction that's worth remembering. Operators are under no obligation to pool. They do not have to. Normally, the reason an operator pools is because they're seeking cost recovery. But remember, there's no obligation that they must pool. Finally, the layman definition basically means bringing together small tracts or fractional mineral interests for the production of minerals within a single spacing unit. So I like to give those different perspectives because I think they all contribute to a better understanding of what pooling is defined as. So the pooling statute, and this is where our authority to pool mineral interests in the state of Colorado comes from. There are two ways this can be accomplished. The first is what's known as voluntary pooling. And we just talked about that on the last slide. Again, it's 3460 116 6A. And I'm not going to read the definition again, but it's when there's two separately owned tracts and the person the entity operating that drilling unit may pool those interests for the development and operation of the drilling unit. The second way is what is famously, or I guess infamously, known as involuntary pooling or forced pooling. That's addressed in 3460-116 6B1. Again, this was created by Senate Bill 19-181. So this is new to us in just the last couple of years. And it states, in the absence of voluntary pooling, the commission, upon application of a person who owns or has secured the consent of the owners of more than 45% of the mineral interests that to be pooled, may enter an order pooling all interest in the drilling unit. A couple of things to note there. So an operator can either outright own those mineral interests themselves, or they have secured the consent of, meaning they've had offers to participate elected by other operators, or they've had mineral interest owners who have decided to enter into leases with that operator of the unit, and that equals 45% of the mineral interests in that unit. Again, this is may. There's no obligation for an operator to force pool anyone. It's a strategic decision on their part. So the pooling application process, how does that work its way through the hearings unit? Well, I'm glad you asked. So the first step is that an applicant, usually an oil and gas operator, submits an application to pool all interests in the already established spacing unit, as Ms. Stanzik talked about. Spacing and pooling really sort of dovetail together, but you cannot pool before a unit is spaced. There has to be a unit already established. So along with the applicant's Rule 505 testimony, and again, we're in this interesting place where we've transitioned to our new rules. So the commission is still going to see orders where there's old rule numbers referenced. Rule 505, which is the world we're in now, that's the sworn written testimony that an operator / applicant must submit with an application. We used to refer to that as Rule 511 testimony. So there might be a month or 2 or 3 months or 6 months from now where you as the commission are reading a pooling application and you see this Rule 511 testimony referenced. That's because that application existed before the rule change, and the information contained in the application might just be a little bit dated, but the new rules do apply, and we're making sure that there's conformity with them moving forward. But we're going to have to be a little flexible with our terminology for the next few months until we work the older applications out of our system. So again, Rule 505 is submitted. That's what I'm referring to as the supporting docs in this slide. The supporting documentation covers a lot of ground. It's going to say, in the pooling context, it's going to say, and again, I'm talking about this from the context of forced pooling or involuntary pooling. They're going to say that the operator is going to say that offers to lease or participate were made in good faith, that they were reasonable. They're going to submit examples of those letters, the dates of those letters, because we as the hearing officers review all that information to make sure that the applicant has complied with our timeframes. In other words, if the hearing on this matter is occurring this week, I do not want to see an offer to participate in a letter that was dated a month ago. That's going to be an automatic red flag, and that's going to be an issue. So we're looking at all of that information to make sure that the operator / applicant has complied with everything contained within Rule 505, previously Rule 511. And I can go into some more of what that looks like if the commissioners have questions about that at the end, but there's a lot of documentation that is now going to have to be submitted with the application. In our old world, they would submit that basically whenever they wanted, if they wanted to get the application processed for review by the commission. Sometimes we would never get Rule 511 testimony submitted, and an applicant would just eventually withdraw their application. We had no time frame under which they had to file that previously. So once the application and supporting documents are received, Ms. Stanzik's staff, that's the permitting staff, they conduct their review of the application to make sure it complies with the technical requirements. And then the next, assuming this presentation makes a lot of assumptions. If there are no issues that technical staff has identified, then the hearing officer will prepare the notice of hearing and provide it to the applicant. The reason we do that is because we make sure that it fits our uniform boilerplate, so it always looks the same coming out of this agency. We provide it with the secretary's signature, or in this case, Chair Robbins' signature, because, oh no, I'm sorry, that's interim Secretary Amaro's signature on the notices now, because Ms. Larson is out. So they're signed by us as an agency, and they're provided to the applicant. And that we give them to the applicant because then the applicant, by rule, has to provide the notice of hearing along with the application to all the interested parties in their interested parties lists. And that's important because it starts the clock running on our petition period. It also sets the date for when the matter will be heard by the commission. The date on our notices of hearing are important to talk about for 1 second, because that is the minimum. It's important to remember that. That is the minimum threshold by which a hearing on the matter can occur, because it's pursuant to our rules that a hearing cannot occur before 90 days after notice. So why that matters is because you might see a member of the public might get a notice of hearing and say, oh, this is going to be heard on February 16th, but that's not necessarily true. That's just the earliest that it can be heard by. We need those dates in there to get other clocks running, like the petition period, et cetera. So most of the time, hearings on a particular docket actually occur after a matter is noticed for hearing. I just wanted to point that out. So if the petition period passes and no one files a petition, the docket is then eligible for the consent agenda, which everyone, all the commissioners are familiar with what the consent agenda is. It's basically where a group of dockets are considered en masse and either approved all together, or the commission has the authority, if it chooses, to pull certain matters off and say, I have a question or an issue with this particular matter, and it probably will not go forward on as part of that particular consent agenda. So assuming that everything is in order, the hearing officer reviews all the file information, everything is prepared and drafted by me or Mr. Thomas. The recommended order is then prepared and submitted, and it goes in front of the consent agenda. It goes in front of the commission as part of the consent agenda, and the commission considers it. And if it gets approved, it then becomes a final order of the commission, which means we actually assign a final order number to that particular docket. It's dated and executed by Chair Robbins in this case, and it is then uploaded to our e-filing system, because everything we do is a public record and it's there basically forever. So that's the process for how things get through the pooling application world, assuming that there are no petitions. That's sort of a simplified, very quick review. So, oh, and there's step 6, which I already went over, the commission review and the final order. So now we're going to actually look at a draft pooling order. And I know this looks a little bit stretched, but I had to make it so this verbiage was at least visible to everyone. So again, this is a recently approved pooling order that went in front of the commission just a couple weeks ago. In fact, we'll go over that in just a second. The reason all the colors are here is because I want to point out very specific parts of this order as we go through it. The first section I want to talk about is the caption. That's the yellow at the top. The caption contains a lot of important information. It's where we identify not just the formations that the applicant is seeking to produce the minerals from. It also identifies the field, the county, the cause number, the particular docket, what type of application it is. In this case, it's pooling, etc. The reason you see the yellow highlighted at the bottom of that introductory paragraph is because that's where it sort of, in a redundant way, calls back to the formations from the caption. And that's just a quick way for you as commissioners to double check what we're doing as hearing officers, that we've correctly replicated the formations requested for relief in the caption also match in that first introductory paragraph. That first introductory paragraph covers a lot of ground. So the teal is obviously the date that the commission is actually considering that application. The purple is the location of the hearing itself. And there's a few commissioners here that remember our pre-COVID world where the commission hearings used to physically occur in other places besides just at 1120 Lincoln Street. And so that's why we actually put that physical street location in, because I'm assuming at some point we'll go back to a world where the hearings travel throughout the state, and we need to correctly reflect that in the record. So the next thing I want to talk about is the red. And the red is the quote unquote unit in which the various interests are being pooled. Remember, pooling occurs after spacing. So what spacing does, as Ms. Stanzik already spoke about, is it establishes the unit. The unit is the size of the lands, the number of wells being sought, etc. So in this case, the pooling application is specifically calling out that this is a 960-acre drilling and spacing unit established for the below described lands, which we refer to as the application lands. That's mimicked down below where it actually physically identifies via the legal description, Township 8 North, Range 60 West, etc. So the red is the unit. Then we get into the dark gray section, which is where you see the cost recovery language. It states that, oh, actually I screwed that up. So I can't even blame Mr. Thomas for that one. I should have captured the first part of that first dark gray line as part of the red, where it says, and to subject, oh no, I sort of did it right. No, never mind. I take all the credit for doing it right. And to subject any non-consenting interest to the cost recovery provisions of 3460.116.7. That's the cost recovery language. So not only is it saying, this is where the applicant is saying, this is a pooling application and we're trying to apply cost recovery language. And here are the wells that they must apply to. It's important to note that because the wells, as you see, they're rattled off here by name and API number, but then there's a parenthetical at the end of them where we define them as wells with the quotes around it. That means that this pooling order only applies to these wells. And if the applicant tries to seek cost recovery to some other well that's not included in this list, they'd have to come back to us with a different application, basically, to either amend this or to start all over. So that's where that comes from, and that's why it's important. Anywhere where we define in quotes, in parentheticals with a quote, we're going to refer to that in another place throughout this order. That's why application lands are defined like that. That's why wells are defined like that. And you're going to see that in other places as we go through this. Now, the light gray is the operator, obviously, who's identified by name and operator number. And then we give them a shorthand where we either refer to them by one word or as just generically the applicant. The rest of the paragraphs you see on this page are not highlighted because they are basically boilerplate. You're going to see them in every single pooling order, with the exception of paragraph 4. Paragraph 4 is going to change. Paragraph 4 is here, 318 little a, and that's actually probably outdated now. We're going to have to update all of our orders because the rule changes. But 318 little a was in there because this is cause number 535. If this were cause number 407, you'd see a different boilerplate there. That would be 318 big A. We're just going to gloss right past that for now. So now we're on the second page, and this is what you see here. The first section I refer to as the order history in the yellow. The reason that's here is because this is what we internally just refer to as the historical order section. What does that mean? Basically, it means that these paragraphs provide a history of all of the oil and gas operations that have occurred on the application lands, basically prior commission orders. Sometimes this is 3 paragraphs like it is here. Sometimes it's 1 paragraph. Sometimes it's no paragraph. Sometimes this is pages and pages long, depending on how many orders apply to the application lands at issue. That's what those orders mean. We as hearing officers will look those orders up on our website through our data search fields, and we will say, we'll verify and look at that and say, does order, for example, in paragraph 5, does order 535.277 say what the applicant tells us it says. Was there an order entered that established a 640 DSU? And we verify that the information provided by the applicant is accurate. Now, there's a lot to digest here. There's a lot on this page. And so the teal areas that you see are what's now required by the new rule 507. It dictates what must be complied with for an involuntary or forced pooling application. In paragraph 8, rule 506A states that the pooling application must be filed at least 90 days before the hearing. That's why you see that. The date you see of October 5th, 2020 in this particular example is the date on which the application was submitted. Again, the hearing officers go back and look at the application and verify, did they get that right? Yep, they actually filed that application on October 5th. And it was, yes, it was at least 90 days before this was heard. How do you guys verify that? Well, you look at the date of October 5th, 2020, and then you go back up to the top and you look at the date that the commission is actually considering this application, and did 90 days pass? Yep, we got that right. So again, here the operators identified Bison. They filed an order to pool all interest in the application lands. Again, there in paragraph 8, application lands is defined above, as we already went over. And then again, you see the formations. You should see redundancy throughout the order. If you see in the caption and then throughout this factual background section, which is what we're in now, and then you see in the order section, which is what we'll get to later, if you see discrepancies, there's an issue there. We made a mistake, and it should not move forward for a consent agenda. So that's how as you go through these things, and you guys are another set of eyes, and we're going to miss something from time to time. Usually what happens when we make a mistake, usually the applicant's attorneys are really, really good at emailing us and say, hearing officer Peskin, there's an issue, there's a mistake in paragraph 8, and then we'll do what we call a corrected order. And that's something we can do administratively behind the scenes. If we made a typographical error, or if we missed a formation in one paragraph. Now, if there's a substantive change, we cannot do that administratively. That must go back before you, the commission. So again, that redundancy is there to make sure it's happening, it's consistent throughout the order. And again, you see at the end of paragraph 8, for the drilling of the wells. Again, wells were defined in that very first paragraph. I'm going to skip down to 10, 11, and 12 because we're still talking about the teal. So in paragraph 10, owners, in this case, working interest owners, have 60 days to review an offer to participate per Rule 506C1. Unleased mineral owners have 60 days to review a reasonable offer to lease pursuant to Rule 506C3. This is a bit of an oddity, this particular order, because if you read in paragraph 10 there, right after the red, in addition, the land testimony and exhibits show that there are no unleased mineral interests within the application lands. This order is a little bit different because in this instance, the applicant is only seeking cost recovery basically against working interest owners. In other words, there was a working interest owner who elected not to participate. However, the operator was able to secure, i.e. lease, all mineral interest owners in the unit. That's why there's particular wording in this paragraph 10 that you might see change in other pooling orders. For example, if that were not the case, this language would look a little bit different because it would state something along the lines of all offers to lease were reasonable and made in good faith, etc. The applicant didn't need to tell us that here because they were able to do that on their own outside of the agency. So moving on to paragraph 11, offers to participate in a well must meet these requirements per 506C1. And that's the technical information we as hearing officers are looking for in the Rule 505 testimony / what used to be 511. You'll see lots of things there in paragraph 11. You'll see that it's specifically mentioned that the commission's pooling brochure was provided, or a link to access it by the applicant to the interested parties. It must identify the particular owner's share of the total estimated drilling and completion costs for the wells. It must also identify for each well, what is that well's location? What is its measured depth? What is its true vertical depth, the lateral length, the total estimated drilling and completion cost, estimated spud date. We as hearing officers look for all of that. If any one thing is missing, we go back to the applicant and say, you missed X, and we're not going to process this until you provide it to the interested parties, and then provide and give them enough time to consider it, and then provide us with proof that you complied with that. Otherwise, we're not going to move forward with processing that application. That happens fairly regularly, that there's a mistake like that caught. And so what does that look like in the real world? It looks like one of the things we've talked about in the past, or you may have heard, is something called an AFE, an authority for expenditure. And that will actually break down in a line item what a well will cost to complete. And then it will show that working interest owner what their percentage of that well completion is based on their ownership percentage. And all of that must be provided to the interested parties ahead of time before we can move forward with a pooling application. So that, let me get to paragraph 12. And again, this is a good example. You see the old rules cited there, because this is a pooling order that was approved by the commission before the rule change took effect. And it references Rule 530 in paragraph 12 in that first line. It's actually Rule 506 now, but this was correct at the time it was drafted and approved. You will see that it says there in the last line, the second to last line, for the wells, but did not provide testimony for any subsequent wells. That goes back to the first paragraph where I talked about the fact that there are specific wells identified by this pooling application by name and API number. That's our way of saying that the information we reviewed only applies to these wells that were identified in the application and the 505 testimony. If there's any other well that the applicant seeks to pool, it's not covered by this order. So that's what that language means. So the purple is where we say that's our introduction to the rest of what we now call the 505 testimony. I know it's a little disjointed, but it's paragraph 8 is the segue from the historical order section into here's what the applicant's asking for in the application they filed on this date. Paragraph 9 in the purple says here's where they complied with Rule 505, and we're about to talk about that below. And then 10, 11, and 12 talk about their compliance with Rule 505. So the red, as you probably noticed, is where we go back to not only the act, but our own rules. So 3460-116 6B1, that's where the legislature changed in Senate Bill 19-181. They changed the requirement that in order for an operator to pool a unit, they must own or have secured the interest of at least 45%, more than 45% of the minerals to be pooled. That also comes from our Rule 506. So I know there's a lot of information on this page. Just about every single word we put into these orders has a particular meaning based on the act and our rules. And that's why I know this is dense, but that's why it's all there. So moving forward, at the top in the yellow, we basically mean, this means that the effect of this order, that pooling the interest in the unit and allowing consenting owners to recover certain costs from non-consenting owners, is consistent with the Commission's mission to protect public health, safety, welfare, including the environment and wildlife resources. It comes from 3460-102-1A1. So in the teal, that's where the hearing officer is summarizing everything that's been requested and requested by the applicant and reviewed by the hearing officer, to say to you as the commission, this is what I've reviewed, this is what they're asking for, and this is what I recommend. And again, it harkens back to the things we've already talked about. They're looking to pool all interest in the application lands, which were identified and defined on the first page, to subject non-consenting interest to the cost recovery provisions of the Act, for the drilling of the wells identified on the first page, for the development and operation of those specific formations that were identified in the caption, the first paragraph, throughout the factual findings. And now here's the hearing officer saying, through these 4 formations again. That's the factual background, the factual findings of the order. Now, we segue into the order section, hence the little header in the middle of the section underlined. This is where the commission is actually ordering the relief being sought by the applicant. And in the purple, we've got the beginning of that section. It should mirror and mimic the paragraph directly above it. That's the commission saying, yes, based on the act, we are pooling all interests in the application land for these formations, for these wells. That's basically all the first paragraph is doing in the purple there in paragraph 1. Paragraph 2 in the red. This is the this comes from 3460-116 6B2, and that's the requirement that a pooling order afford each owner in the unit the opportunity to receive a just and equitable share of the proceeds. It's pretty much straight from the act. 3 in the paragraph 3 in the green identifies the working interest owners against whom cost recovery applies, and contrast that with what we have in paragraph 5 in the dark gray. That's where the applicant is saying to the commission, here are the mineral interest owners against whom cost recovery applies. Remember, based on this particular order and the facts of this application, paragraph 5 is interesting because if you look after the colon in 3460-116-7 CRS, it says none. That verifies what you read in the previous paragraph during the factual findings where the applicant said there are no unleashed mineral interest owners in this particular unit. And so we're not seeking cost recovery against anyone in that case. But you will notice in paragraph 3 in the green that there are 1, 2, 3 entities against which cost recovery is sought on the basis of them being working interest owners. And so cost recovery does apply in those instances. And those are, sometimes you'll see parties identified in both, sometimes one or the other. So moving on to the final page of the order in the yellow, we have language that comes directly from the act. It is the cost recovery language that's identified in 3460-116-7C2. That language is lifted directly from the statute and it's there. That's what the commission is ordering, that is what happens after the recovery of those costs specified by the act. The teal language is pursuant to 3460-116-8. It's where we as the agency get the authority to require operators to provide us with monthly production data for their wells. We as an agency track that. It's something that I don't want to go off on a tangent, but that's something that will become very relevant in the instances of payment of proceeds cases. It's why operators have to give us that information, why we track it, and when a royalty owner will use that information in the event they feel like they're not being paid correctly. The purple paragraph is very important because that is that's pursuant to the act as well, 3460-116-7A3. It prevents liability from attaching to non-consenting owners as it relates to the operation of those oil and gas wells that are pooled from this order. Finally, we have the red, which is from 3460-116-7A4. It prevents an operator from utilizing a surface location without that owner's consent. After this draft order is approved by the commission, in the event it is then assigned a final order number, which if you remember from the first page of this order, it said 535-XXX. That's because at the time we draft this, we don't have a final order number. It's just recommended. The commission can do whatever it wants with that order. It can approve it, it can deny it, it can hold it over and say we have questions about this. But in the event the commission does decide to approve it, we then, as the hearing officers, use a sequential number that is the next one in line after whatever the most recently issued 535 order is, because each cause number has its own series of orders. And we will then put that sequential order number in place of all of those X's after the cause number. So we insert that in the place of the X's. And it's then dated the date as of the date it is signed by what is normally the commission secretary, Ms. Larson, but in this case, it's Chair Robbins, and it then gets uploaded into our e-filing system. And this order, for all intents and purposes, is done. So I know that was a lot of information. Is there anything I can answer on behalf of the hearings unit?
All right, unmuting myself and looking to my fellow commissioners for questions. Commissioner McGowan, you're first.
Thank you, Mr. Chair, and I apologize. I thought I had figured out the non-consenting working interest owner versus the non-consenting unleased owner, and now I think I'm confused again. In either case, if you're a non-consenting participant, you will receive a lesser royalty until the upfront costs are recovered for both of those parties, correct? But then I think I still need to understand the differentiation between a working interest owner and an unleased owner. In my mind, a working interest owner perhaps is someone like an operator or a company that has leased those minerals, and the unleased owner is maybe a small, like an individual who somehow has mineral rights but hasn't leased them to anybody. But I'm not sure I quite have that straight. So I guess I need to delve into that a little bit further. Thanks.
Well, I don't want to step on Commissioner Gonzalez's toes. He probably is more suited to answer that than I am. But the answer to your question is yes. It really depends on who owns what in the unit. It's not always a cut and dry. Sometimes, I will say this, more often than not, a working interest owner, as Ms. Stanzik said, is usually another operator or someone who has the ability to develop those minerals. But that doesn't preclude a working interest owner from just being an individual. And so it really is not, it's not that I get where you're coming from, Commissioner McGowan, because the way my mind works is I like things to fit into neat little buckets, but that's not always the way it operates in this world. And sometimes there are blurred lines between who owns what and why and when and where, and that really does depend on the nature of the deeds, it's the norm in Colorado for the mineral estate to be severed from the surface estate. That's the norm. That doesn't mean that that's always the case. I've seen protested pooling applications from a few years ago where a mineral interest owner was the landowner who had the mineral estate intact with their surface rights, and they owned thousands of acres. And so there was a great deal of money at stake, millions and millions and millions of dollars. And that in that particular case, the mineral interest owner was also the landowner, the working interest owner for all intents and purposes. So it really just does depend on what is happening with regard to legal title in that unit. And I know that probably doesn't clarify much of anything, but I would be happy to hear from Commissioner Gonzalez.
Commissioner Gonzalez, would you like to weigh in here?
Sure, I'll just give a quick addition to what Hearings Officer Peskin laid out there. And the way I think about it is that a working interest owner is just a cost-bearing interest owner, right? So someone who has the opportunity to participate in the well and to carry the cost of that development. Now, that means that it could be an unleased owner or someone who is under lease. As you think about it through the pooling applications that we've seen to date, and in the pooling application that Mr. Peskin used as an example, those two entities are really broken up in a pretty typical fashion, meaning that the working interest owners and the non-consenting working interest owners that are being pooled, most importantly, are typically, they are lessees, meaning that they are operators who have secured the right to operate through an oil and gas lease. And then in the next paragraph in those pooling applications, the unleased interest owners, mineral owners are identified. They are also technically working interest owners, but we don't think about them the same way because they have not given their right to operate to an operator or to another individual or entity through an oil and gas lease. So that's pretty much the way that you can think about it, Commissioner McGowan, and for the rest of the commissioners, is when we're looking at these pooling applications typically, and we can point these out when the non-typical situation occurs, but typically the working interest non-consenting owners are those operators or entities that have an oil and gas lease, and the unleased mineral owners are those that are actual mineral owners, own their minerals, and have not given their rights to operate to another entity.
Thank you, Commissioner Gonzalez. Commissioner McGowan, did you have a follow-up?
Yeah, so thank you. That's helpful. So as a working interest owner, if you decide you do not want, you can decide to not participate in the cost sharing, in which case it puts you then in that category of, I'm going to see the benefits or the royalties and the amount that I get after the upfront costs have been recouped by the operator who's deciding to do the recovery of the minerals. Is that so? You fall into a similar category as the non-consenting unleased owner, as far as your participation in royalties.
There's a distinction I think that could be helpful here, and I'll let Mr. Peskin clear up anything that I may misstate or may be contradictory to practice. But that's that when a working interest owner, an operator, and we'll call them a non-operator, meaning someone who's not actually operating the development, someone who's participating or not participating in the development, that owner is likely under lease, right? And that's the way we're thinking about them, meaning that they have an obligation to pay royalties out of that production to the mineral owner. They themselves are not a mineral owner and therefore do not receive the benefit of the royalty during the cost recovery period. They are simply out of the well. They have no cost obligations and they have no revenue. They're not entitled to any revenue aside from the revenue that is going to the actual mineral owners. So they do not receive a royalty the same way that an unleased mineral owner receives a royalty.
Mr. Peskin?
Thank you, Chair. Yes, I agree. And I think one thing that helps me, Commissioner McGowan, think about this is, and Commissioner Gonzalez touched on this, it's when you're a working interest owner, it gives you the right, the legal right to develop those minerals in a unit, but it doesn't necessarily mean that you own the minerals. And so as Commissioner Gonzalez said, a working interest owner has secured those minerals from someone else. That someone else is who's owed those royalties.
Commissioner McGowan?
Okay, so it's more complicated than I even thought. So, so if you are a non-consenting working interest owner, you've already entered into an agreement with an owner of minerals to lease them, but somebody else, this is probably not the right term, it's the only thing, someone else beat you to the punch and wants to develop all the minerals in the unit. They haven't leased them all, or they don't own them all. You're another operator who has already made agreements with mineral owners in that spacing unit, and it's being pooled. So is your lease null and void if you decide not to participate, and it just goes back to the original mineral owners? Because I'm just trying to figure out what happens what's the benefit of participating if you've leased minerals from a mineral owner, and another operator is going to develop within that area, and the original lease still has to be honored. So does the funding just go directly then to the original mineral owner who leased to the operator who's not participating? Sorry, I didn't realize this. Now I'm understanding how complicated this is.
Chair Robbins?
Yeah, Mr. Peskin.
I think you lost me there at the end, Commissioner McGowan. I'm not entirely sure. Thank you, Commissioner Gonzalez.
Commissioner Gonzalez.
I'm guessing Commissioner Gonzalez maybe is understanding what I'm trying to get at.
I think I do understand what you're trying to get at. And basically, what happens is if you look at or you think about the diagram that Ms. Stanzik put up with the different squares, right? You saw the drainage radius, and you saw all the different squares. There are different leases. Not all of those leases, or not all, let's think about it just going one step back as mineral owners, mineral estates. Each of those mineral estates is owned by a different mineral owner. Each of those mineral owners can lease their rights to an operator. They don't have to be the same operator. And so what's required in our pooling statute is an operator that has 45% or consent from 45% worth of those either owners or working interest owners, meaning lessees, within that unit, then they can operate. And so some operators, it's their business model to be operators and to do just that, to form a unit that will have different mineral interests and different leasehold interests within that unit, and they pull them all together. There are other businesses in the state and in this country where the company model is basically to be a non-operator, in which case they are going to sit back and let another operator operate and develop while they receive their net proportion of the revenues, and they participate or don't participate in the costs of that development. So there's multiple layers to think about it, and it is a complicated I guess process pooling is. And that's why, you know, we're going through this informational docket, and I'm happy to provide answers as best I can, as well as Ms. Stanzik and Mr. Peskin. And we do have an operator who's going to be presenting on this same topic after this, who may have some diagrams or some helpful visuals that may explain it a little bit further.
So sorry. Yes, sorry. So if you are the operator who's not actually doing the work, but you have leases for some of the minerals in the unit, you have to honor the lease that you have with the original mineral owner. And then, so not that this is here or there, but then how does that benefit you, and how do you make money? So you're going to assume that the person who is actually going to do the operating and the drilling is going to pay you enough for your mineral interest so that you can pay, you can honor your lease with the original mineral owner and still earn revenue.
There's not revenue associated with being a non-consenting working interest owner or a non-consenting non-operator. There's various business reasons why you would make that determination to participate or not participate. There's a myriad of those reasons. I won't get into all of them. They go operator to operator. But in general, the royalty owner, the mineral owner, will always get paid because they are paid a proportion of the production, regardless of who produces it. The lease will stay intact so long as production is occurring on the lease, based on whatever the lease terms are on kind of what states the level of production that will maintain that lease. So the operator will still have the rights to that lease, and the mineral owner will still get paid. The non-consenting working interest owner will not receive any revenues until the end of the cost recovery period, which is otherwise known as payout.
Okay, thanks.
Commissioner Messner.
Thank you, Mr. Chair. And thank you all for that presentation. I mean, I think that was really good. It was thorough. You know, I've seen parts of that presentation before. I feel like I've got a pretty good handle on it. And so I thought that was really well done. Mr. Peskin, I do appreciate you breaking down the submittals that we get, you know, the orders, because I also think that's helpful as far as going through and making sure how these things tie back. You know, I've reviewed a number of these now. So my question is not substance as much as, you know, some thoughts on how to make it easier for us to review these. Because what I've found myself doing is because I'm always wanting a little more information than what is provided in that order. You know, particularly I want to know where it's at. And so I love, you know, townships and, you know, all that information, but, you know, my mind works on maps. And so I don't know if it's possible as we get these to hyperlink those so that we are able to like place those, or to be able to receive, how difficult it would be to receive a location map as we get those, so that at least when we're looking at them, it's easier just to understand where they're at. I mean, I understand that the counties there, the bounds and meters are there. I mean, it's all there. And so I've certainly utilized that in order to find it on a map, but that inevitably takes, some time to sort out in order to get that. And so to me, that would be really helpful. And then, I know that as a hearing officer, you're receiving significantly more information than is provided, in that order. And certainly the goal of mine would not be to, try to discount any of the review and the process that has gone through, but also some easier way for me to be able to access some of the information that you've already reviewed. Understanding that it's there, I can place, the docket number, in the website. I mean, I can do all that, but if there was a way to just click on something and be able to access that, to me, as I'm reviewing this, understanding because I'm the last check and balance, and I do my homework and I do go through all these things, that would be helpful for me. So that was just a thought. I don't know how difficult that is to do or if that's appropriate, but that's kind of what I was thinking as you were going through that form. So,
Mr. Peskin, and also Ms. Stanzik has unmuted herself.
Thank you, Chair. Great points, Commissioner Mesner. A couple of things, just from a sort of a global perspective. We have entered into this e-filing world, which is going to address the largest part of your concern. The issue we had before e-filing was everything existed, even though it's all public record, everything existed in our internal sort of shared drive world, which really was not intuitive or easy to access by anyone except people who were in it every day. If anybody ever emailed me and said, Mr. Peskin, I want to see the 511 documents for docket number blah, 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 I would, without hesitation, I would just email them because that's public record. But in e-filing, when you guys as the commissioners are now reviewing a specific docket, you are going to have access and immediate ability to review all of the information that I see. Everything is going to be held in one electronic, publicly accessible place. So that's number one. Number two, I agree with you. Without me going to our website and doing the entering township range section in our map, which our map is an incredibly powerful tool, I will also say that it took me more than a year of being at the commission before I had any idea what I was doing. And sometimes it's still embarrassing how bad I am with the map. One of the things that has changed in our rules over, and Ms. Danzig can correct me here, the last year, or I think it was in 19 when we required this, operators with their application must not only submit a physical, a map, they must attach a map to the application, but the application itself must also identify the nearest public crossroads. So now we sort of marry those two concepts together. You're in the e-filing system, you think to yourself, I'd really like to see where this is on the map. Open the application. If you go into the e-filing system, you open the application, you'll see a map attachment, but also on the first page of any application, you'll see the nearest public crossroads, and you could just put that into Google if you wanted. We wanted a way, because we understood that the public didn't know what 6 North, 58 West meant, and so we wanted to make that easier for them as well. So that will all be easier moving forward. Now, I might be mistaken, and Ms. Stanzik, I'm not sure if I'm wrong about this, but I'm not sure if no, we've had pooling applications filed in the e-filing system, haven't we?
Oh, yes.
Yeah, just a few so far.
Quite a few.
Oh, okay. Well, so Commissioner Mesner, I would encourage you to get in there and mess around, look at a pooling application, open the app.
I think my point is, and I'm not trying to be a pain here. My point is that I know it's there and I'm able to access it, but when we get our portfolios, I have to actually take this information because it's just a PDF in my portfolio, and then I have to write it down on a piece of paper, and then I have to go into the computer, and then I have to type that stuff in, and the e-filing system, and then I can access this stuff, right? So I'm not saying it's not there. I'm just saying, for ease of review, particularly in the past where we've had, potentially in a consent agenda, you've got, 15 or 20 different, things that you're reviewing. the ability to be able to click on a hyperlink to that, or to just have that in the portfolio, which I know is more difficult. So I think a hyperlink or something that's more intuitive for me to be able to access it. And this is just structural thing, right?
Sure.
But I acknowledge that information's there and I've been able to access it, right?
Correct me if I'm wrong, Commissioner. Sorry, Chair Robbins.
Go ahead.
Okay. Correct me if I'm wrong, Commissioners, but I don't believe the Commission has yet reviewed a pooling application that has worked its way through the e-filing system. So when you're talking about portfolio, you're talking about the previous world of where all of our documents were stored internally on our shared drive. Going forward, that you're not going to get a portfolio anymore. You're going to see a docket number as part of the consent agenda, and you should be able to click on a link, take you to the docket where you'll see everything with just a click of another link. I might be wrong about that, but Ms. Stanzik, you're making a weird face.
Ms. Stanzik?
Mr. Peskin, I'm not sure exactly what you're talking about.
Just in looking at a docket internally.
Well, it's all there, and to add what's been requested, a link that just zaps you right there, would require a revision of our system. I don't think it's very difficult to navigate. I would add that in our maps, that every application is mapped. There's a map layer for pending applications. If you turn that on and go to the township and range, with that layer on, you just put your cursor there and the map tip box pops up. It gives you the docket number. It tells you if it's spacing or pooling. So there are a lot of tools that once you get the hang of it, it's really pretty easy to use.
Okay, Commissioner Nanjapa, I believe you had a question.
Thank you, Mr. Chair. I did. I just saw Ms. Stanzik raise her hand though, so I didn't know if she had something else to add.
Ms. Stanzik?
I would add that I'd certainly be happy to help everyone use the brand new e-filing system, use the maps. For those of us that use it all the time, it's second nature. They're very powerful, as Mr. Peskin said.
Thank you, Ms. Stanzik. I think each of us individually may take you up on that. Ms. Nanjapa, or Commissioner Nanjapa?
Thank you, Mr. Chair. Yeah, and I just wanted to echo what Commissioner Messner said, that this was really helpful. You know, we've seen these pieces before, but having it all together and just with all the different questions that we've all had, this is making something that was a little bit fuzzy for me a lot more clear. So I really appreciate that. And also just a shout out to Mr. Peskin for the humor that you inject into your commentary. I appreciate it. So I had a question, I'll ask this of the operator as well, but in the pooling order history, where it shows, maybe what was originally put in as a application and then vacated and then sort of replaced with a new order, it seems that the acreages tend to increase and the number of wells tend to increase. And I was just kind of curious about why that is. Is that because there are maybe more consenting owners that have been secured, or is it differences in technology? What are the reasons? Mr.
Peskin or Ms. Stanzik?
Ms. Stanzik can answer this better than I can, but you're exactly right, Commissioner Nanjapa. It's a combination of both. Usually, we'll see sometimes operators come back and say, "This was a 640, now we want a 1280. This was 10 wells, now we want 24. This was 2 formations, now we want 4." We've identified more interested parties through an updated title search. We've become aware of someone who was left out of a pooling order. We want to reshape the unit. We want to bring other people in. It is most often, in my opinion, tied to technology or just updated information as it becomes available to the operator with regard to public records, et cetera. But I'll let Ms. Stanzik reply as well.
Ms. Stanzik?
Thank you. Yes, A lot of the changes that you'll see when you read through the history of the orders, it's all about the change of technology. Most of what you've seen is limited to the DJ Basin, and the implementation of horizontal drilling has just totally changed how those reservoirs are developed and what's the most efficient way to do it, and therefore what's the appropriate size for a drilling and spacing unit, what are the appropriate number of wells within a unit. It's all about efficiency and the new technology that allows increasingly more efficient. When you look, some of the orders that are listed in the history are based on vertical wells and directional wells, when you could only drain 40 acres. And now you can drill a horizontal well that's a mile long or 2 miles, 3 miles long. It's that shift.
Thank you.
Hearings Officer Peskin.
Chair Robbins, if I may, I'd like to share my screen just to very briefly address Commissioner Mesner's concern. I want to make sure that I'm understanding. Can you guys see the e-filing system on my screen?
Yes.
Okay. So these are all my assigned dockets now within the e-filing system. And I just want to make sure, because to me, a picture is worth 1,000 words. I want to make sure we're talking about the same thing. I'm going to click on this pooling example right here that ends with docket number 280. Just double click on this. And you as commissioners should have access to all of this information. And we have not yet conducted our e-filing training. So I understand that this may be new to a lot of people. We're working on our training as we speak. But this is the docket. This is a pooling docket matter. If you scroll down and you look at the attached documents, which is this window pane right here, you guys are going to see everything that I get to see. And this is where everything is going to be filed and uploaded and attached, whether it's done by the operator or me or permitting or whomever is filing something into this docket. The entire record is going to exist in this window. Here is the application. It's the very first document. If you double click on this, it opens a separate window for that attachment. You have to double click on it again. I'll maximize this so it looks a little bit bigger. And then, so here's the application in this particular pooling. Here is the township range and section, but then there is the public crossroads identified. And then if you scroll down at the end of this application, you will see there's the map. And I know that, Commissioner Mesner, I know that you've seen this information before. As you were saying, you had to go and look it up another way. But this is where it's all living now in one centralized place, all in the exact same place where all documents are uploaded, consisting of the entire record for any particular docket, which is the beauty of our new system. And I just wanted to share that. I don't know if that addresses your concern, or if you already knew this or had seen this before. I apologize if it was redundant.
No, I appreciate that. And I actually appreciate, I mean, I know that this information is out there. I know that it's accessible. I mean, I get it. I think my point was much simpler than this, which was, at least currently up until, today, I mean, including today, when we receive the information in our portfolios, it's just a PDF, of the draft order or draft report. And so in order to be able to, develop more information, I mean, I understand all I have to do is type this information into a separate, website or e-file system in order to be able to access it. I was just wondering if there was the ability, as we got these portfolios, to just hyperlink it. And so I didn't know if that was a difficult thing or not. Yeah.
Additional questions? Hearings Officer Peskin, kind of a different topic, but we've received, or the public has perceptions about sort of the involuntary pooling aspect of pooling. Can you give us some perspective of how often, so we see a lot of consent agenda items in which things are sort of okay. How often do we end up in the involuntary pooling sort of situation?
Chair Robbins, do you mean based on a percentage of pooling
I mean, like-
applications overall?
I mean, like where we have folks that are petitioning, or they're objecting, or
Oh.
they're protesting, that kind of situation. We don't see much of that on our consent, and I'm just trying to get some perspective. And I guess I'm asking the question for the public at large.
So that's a complicated question to answer. It has been never-ending evolution in my time here at the commission now, which is going on almost 3 years. When initially in the olden days, and that's due to the changing in rules and the act, et cetera. But in the old days, it was almost invariably when we had a petitioned or protested pooling application, it was almost always another operator. And that was based on, I can't recall the commissioner that mentioned it. It might have been Commissioner Gonzalez, but it was sort of or maybe it was Commissioner McGowan who used the term, beat them to the finish line. And a lot of times that was it, because you had operators within the same unit who both had the ability to produce those minerals as a working interest owner. And you would see one operator say, no, I'm protesting because your plan commits waste and my plan is better for everything. It's a more efficient plan, et cetera. We've really seen that sort of go by the wayside, where operator v operator in a protested pooling application has sort of become a thing of the past. It's not absolute, obviously. Now we see more protests or petitions from members of the public that are basically concerned with the health and environmental aspects of oil and gas operations. I would say from my perspective that it's difficult. That's a difficult row to hoe, because the real basis in a protested or a petitioned pooling application, if you're simply saying I dislike oil and gas operations, is a tenuous position to be in, because the legal recourse is usually tied to an argument based in the fact that my offer to lease was unreasonable or not made in good faith. And that, from a hearing officer's perspective, we're sort of boxed in, right? How can we evaluate a protest or a petition in a pooling application? And so we are seeing less of those, because I think the public is becoming more educated about this process and the fact that environmental health, welfare, safety, wildlife concerns are more appropriately addressed in a permitting context or in the spacing context, which is we're going to see that shift to our OGEP process. And so from the members of the public, we've seen protested pooling applications. I would say petitioned/protested pooling applications have been in decline for some time now, with the exception of a few notable dockets.
Thank you, Mr. Peskin. Do we have other questions for Mr. Peskin or Ms. Stanzik? Seeing none, we do have another presentation. It's going to be from PDC Energy on kind of a specific sort of, let's run through one of these from an operator perspective. I might suggest we take a 10-minute break. It's 11 o'clock and we did have a break scheduled at 11. So let's plan on coming back at 11:10, and that'll give PDC an opportunity to get ready for their presentation, which we look forward to.